organized by Jadhavar College of Law. What began as a congregation of bright legal minds has now evolved into the stage of true excellence, where only the finest advocates remain. Over the course of this competition, these courtrooms have witnessed not merely arguments, but intellect in action. Not merely submissions, but the spirit of law articulated with conviction, precision, and clarity. From an impressive participation of 28 teams which have come across from all angles, aspects of India, through rigorous preliminary and knockout rounds conducted across 14 courtrooms since yesterday, have evaluated by an eminent panel of external judges, internal faculties, assessors, we now have arrived at the final stage, with the best of the best shall contend for distinction. Today's participants are not merely competitors, they are advocates in making, custodians of justice, and voices of future legal fraternity. My lordships, we are deeply privileged to be in this presence of honorable judges whose wisdom, experience, and unwavering commitments to justice lend immense dignity and credibility to these proceedings. Their presence transformed this courtroom into a true temple of legal learning. On behalf of Jadhavar Law College, I, the courtroom officer, and my team, we extend our deepest respect and heartfelt welcome to the honorable judges. Your guidance today will not only determine the course of competition, but will also share perspective, refine advocacy, and inspire excellence among all present here. As we commence this final round, let us remember this is not merely a competition, but a celebration of the rule of law, reasoned arguments, and of the enduring pursuit of justice. May I request the attention of all the present in the court. We are in the Moot court and we are going to observe the final round, the grand final round of this competition. The matter listed before this honorable court is Arnav Rajput versus State of Burundesh and another, which is under the criminal inherent jurisdiction. The learned counsel appearing for the petitioner, the team code is TC08. The learned counsel appearing for the respondent, the team code is TC016. Each side has been allotted a total time of 45 minutes, including rebuttal and subbuttal. Your Lordship, with your permission, I would like to place few instructions on record for the smooth conduct of these proceedings. Much obliged. All participants and members present in this court are requested to maintain utmost decorum, silence throughout the proceedings. You are kindly requested to keep all your electronic devices should be on switched off or airplane mode. The learned counsel may rely upon barracks, compendiums, and other relevant material, may seek assistance through the courtroom officers if required. Your Lordships are please may now proceed. This honorable court is now in motion. May I request the learned counsel for the petitioner to approach the podium and commence their submission.
The counsel seeks permission to approach the dais. Much obliged, Your Lordships. With utmost respect to your leadership, the counsel seeks permission to collectively address the benches, Your Lordships. Much obliged, Your Lordships. The counsel is appearing on behalf of the petitioner in the matter of, in the present case of Arnav Rajput versus State of Burundesh and another. The petitioner has approached this honorable court under section 528 BNSS, which reads as follows. Section 528 BNSS, saving of inherent power of High Court. 528. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code or to prevent abuse of the process of any court or otherwise to secure the ends of justice. If it pleases Your Lordships, may I state the facts of the case? Much obliged, Your Lordships. May it please this court, this case begins in 2016, Your Lordships. Not with an act of aggression, but with an act of adolescent romance between two neighbors. In 2016, a voluntary romantic relationship blossomed between Arnav, then aged 17 years, and Meera, then aged 15 years. There was a very little age gap between the two. There is a very close in age here, Your Lordship. This was a bond built on mutual affection which was widely recognized within their social circle and which was entirely free from coercion or misrepresentation. After this, because of their relationship, this led to a mutual physical intimacy between them. It has been given in the fact sheet that there was a mutual physical intimacy between them, which led to a pregnancy. Later that year, after that, both the families were informed. Rather than seeing it as a crime, the family saw two children at crisis. And after that, they reached at an amicable consensus because of that, because they saw two children at crisis. With Meera's informed consent, the pregnancy was terminated at a legal medical facility. For the next 7 years, that is from 2016 to 2023, there was no FIR or police complaint being filed either by Meera or any of her family members. From 2016 to 2023, there was no FIR or police complaint being filed. In 2023, after that, acting with their own volition, that means with their very own consent, both of them decided to formalize their lifelong bond, Your Lordships. The fact sheet says lifelong. The emphasis should be given on the word lifelong bond into marriage, Your Lordship. They formalized their relationships into marriage in 2023. After that, from 2023 to 2025, that is for the period of 2 years, they held a stable matrimonial home. After this was an ultimate validation that their past was not any criminal act. It was a shared journey which they had, both of them. But in 2025, there arose certain personal differences and financial differences which led to the irretrievable breakdown of the marriage in 2025. In January 2026, subsequently to the irretrievable breakdown of the marriage, an FIR was being launched by Meera stating that rape and penetrative sexual assault was done under the POCSO Act, Your Lordship. After a delay of 10 years, Your Lordship, the offence was committed in 2016 and the FIR was being launched in 2026 after a delay of 10 years, Your Lordships. If Your Lordships are well versed with the fact, the Council seeks permission to proceed with issue 1.
When the pregnancy of the Meera was terminated in this year, in the year 16?
In 16 only, Your Lordships.
Whether there was any consent of the Meera?
With Meera's informed consent, the pregnancy was terminated, Your Lordships.
Whether minor can give consent?
No, Your Lordship, the minor cannot give consent because below age of 18, the minor cannot give consent to all these.
No, for termination of pregnancy also, the consent of the other parents of the Meera was taken at that time, or only the informed consent of the Meera was pregnancy was terminated?
The family came at a amicable consensus, that is they decided, they also took the opinion of Meera. With Meera's informed consent, they all together decided to terminate the pregnancy.
What was the period of the terminacy?
Your Lordship, it is in 2016.
The fetus of age of the fetus, duration of the
Duration of pregnancy.
Your Lordship, the facts are silent.
Even you can also assume the fact for replying the answer of the question.
No, Your Lordships, we have been told that we cannot assume facts. Your Lordship, we have to stick to the facts.
Yes, proceed.
May I proceed with issue 1?
Yes.
Much obliged, Your Lordships. The present council would be dealing with issue 1 and my co-council would be dealing with issue 2 and 3. Issue 1 reads as follows. Whether the High Court, in the exercise of its inherent powers under Section 528 of the VNSS corresponding to Section 482 of the CRPC, is competent to cause an FIR involving non-compoundable offences under the POCSO Act in cases where the parties have subsequently entered into valid matrimonial relationships. Your Lordship, the answer is the High Court is fully competent to cause an FIR involving non-compoundable offences under the POCSO Act in order to secure the ends of justice, Your Lordships. Your Lordships, understanding the interpretation of Section 482 CRPC from the landmark judgments laid down by the Honorable Supreme Court, Your Lordships. Firstly, from the judgment of 1992, State of Haryana versus Bhajan Lal. Later on, Jyan Singh versus State of Punjab, Narinder Singh versus State of Punjab. Your Lordship, there were 7 principles laid down in Bhajan Lal judgment, Your Lordships, which laid down that if the case fits into any one of the principles laid down in the Bhajan Lal judgment, then the court would be competent to cause that FIR, Your Lordships. Reading down the principles laid down in the Bhajan Lal judgment, Your Lordship, I would like the Honourable Bench to refer to page 13 of my written submission. Reading down the 7th principle, Your Lordships, from that judgment, where a criminal proceeding is manifestly attended with malafide and or the proceeding is maliciously instituted with an ulterior motive for breaching vengeance on the accused and with a view to spite him due to private and personal grudge. Your Lordship, it is very clear from the factual matrix of the case, Your Lordship, that there was a malafide intent at the part of Meera, Your Lordship. If Your Lordship, Meera, if we assume, Your Lordships, in arguendo as well, that there was not consent to that act, Your Lordships. At attaining the age of majority, she could have filed the complaint in 2019, Your Lordships. Your Lordships, from 2016 to 2023, 7 years mere silence, no FIR being filed, no police complaint being registered. After attaining the age of majority, from that period also 4 years, no FIR being filed. The FIR being filed, after that is stable matrimonial home for 2 years, Your Lordships. When the FIR was being filed, at that time the marriage irretrievably broke down. After that, Your Lordships, when the marriage irretrievably broke down, the FIR was being caused, the FIR was being filed, Your Lordships. This clearly, the factual matrix suggests, Your Lordships, that there was a malafide intent, Your Lordships. The delay of 10 years suggests clearly that there was a malafide intent at the part of Meera, Your Lordships. Your Lordships, coming down to the...
So on the basis of the delay in lodging report, whether the FIR can be punished?
Yes, Your Lordships. With respect to this, Your Lordships, may I submit one judgment of the Honourable Supreme Court, Your Lordships?
Only on the basis of the delay in lodging FIR,
Your Lordship, there are other factors which I would be stating in my further
which
argument.
judgment is that?
In the judgment of Kunal Chatterjee versus State of West Bengal, which is the recent judgment of 2025 of the Honourable Supreme Court, wherein I would like the Honourable Bench to refer to para 2nd, Your Lordship.
What is the ratio left on that?
The court has caused the FIR, Your Lordship, stating that there was a delay of 3 years in filing the FIR, Your Lordship. The case is, in that case as well, a 15-year-old minor later on, at the attaining of the age of majority at the age of 18, filed a FIR. The court came down to the opinion, Your Lordships, that now, coming to this stage, Your Lordships, the more importance that no medical evidences could be gathered, no forensic evidences could be gathered, and filing the complaint after a delay of 3 years clearly suggests that the court, that this petition has been filed, that this FIR has been filed with a malafide intent, and the court has caused the FIR in the 2025 Honourable Supreme Court judgment, Your Lordships.
What, according to you, is the malafide intent in the present set of facts?
Your Lordships, the malafide intent can be gathered from all the relevant facts and the circumstances of the case.
What facts?
Your Lordships, firstly, they having a mutual physical intimacy, Your Lordships. At the in 2006.
We are speaking about malice of intention. So what is the malice of intention according to you in these facts?
When the marriage irretrievably broke down, Your Lordship, when the marriage broke down, it was very convenient to just gain a personal vendetta against that my client, Your Lordships, who was also at the age of 70. He also didn't know the consequences of that act, Your Lordships. That is the claim, that at the age of 15 she is not going to understand the consequences of the act. My client at the age of 17 also not going to understand the consequences of the act, Your Lordships. When the marriage got irretrievably broken.
So the minor cannot be the accused in the POCSO case?
No, Your Lordship, the minor can be accused in the POCSO case, Your Lordship.
So is there any exception that the person who is minor can be exonerated from the charges of the POCSO?
No, Your Lordship.
So then, if there would not have been any intention on the part of that, if that would have been considered as that he was not having intention because he was not having the age of consent, then that would not have been the offence.
Your Lordship, but subsequently marrying my client, Your Lordship.
As you have contended that when the offence was committed or alleged offence was occurred, at that time the Arnav was only 17 years of age. Therefore, I am telling you.
Your Lordship, the fact states that there was a mutual physical intimacy. which can be gathered that both of the parties under their romantic relationship consented to their sexual relationships, your lordships. Mutually everything was done. Now, your lordships, stating that it was unilaterally done, which the very meaning of penetrative sexual assault means that unilaterally done, not out of, that is being done out of lust, your
You are
lordships,
saying
not
that
out of
that
love.
was the consensuous sexual relation between them. But whether the consent of the minor girl can be considered?
No, your lordships, under the POCSO Act, any victim under the age of 18, the consent is legally irrelevant. Agreed, your lordship, the council agrees this fact. But your lordship, this honorable High Court also has the inherent powers under, it has the extraordinary powers under this jurisdiction, your lordship, so as to understand whether the ends of justice are being secured, your lordship, and whether this is a futility of trial and this is an abuse of the process of court, your lordship. We have approached this honorable bench, your lordship.
If the consent is immaterial, the minor's consent is immaterial, and if she is alleging that now she was ravished by the Arnav, then that will not be the injustice with her if the FIR is quashed only on the ground of delay.
Your lordship, the reason is not only delay, your lordship. My point is, the court needs to consider all the relevant facts and surrounding circumstances, your lordship. The court needs to consider the acts which have been done from 2016 till the time the 2026 the FIR being lodged, your lordship. Now, from 2016 to 2026, the relevant much obliged. Your lordship, with respect to FIR which I was stating, your lordship, there is a case law on page 26 of my written submissions, your lordship. In the case of Iqbal versus State of UP, your lordship, which states, your lordship, that in frivolous or vexatious proceeding, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the government, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under section 482 CRPC or article 226 of the Constitution, need not restrict itself only at the stage of a case, but is empowered to take into account the overall circumstances leading to the initiation/registration of the case, as well as the materials collected in the course of investigation. Your lordships, no medical evidences can be collected right now, no forensic evidence is can be collected right now for the offence which took place 10 years before, your lordships. Your lordships, coming down to the third point, your lordships, that other grounds in the Narendra Singh versus State of Punjab, your lordships, there are other grounds which have been stated by the court. The court says these are the guiding principle which should decide whether the court should pause the proceedings or not, your lordships. I will just state down the grounds which have been laid down, your lordships. One of the grounds is, your lordships, the timing of the settlement, your lordships. I would like the honorable bench to refer to page 12 of my written submissions, your lordships. 29.7 point, your lordships. I will read from line number 2, your lordships. Those cases where the settlement is arrived at immediately after the alleged commission of offence and the matter is still under investigation, the High Court may be liberal in accepting the settlement to cause the criminal proceedings/investigation. Your lordship, the High Court says even if the offence is committed, after that as well, your lordships, if the parties decide and they amicably settle through marriage, your lordship, the court will consider this may be liberal in causing the proceedings. Your lordship, now the facts of the case are more advancing towards my clients, your lordships. How, your lordships? The settlement, first, your lordship, that marriage was not a settlement, your lordship, that marriage was out of the pure love, your lordships. Your lordships, this was not a settlement being done when the case was being filed, the FIR being filed, and after that we have reached out for the purpose of marriage, your lordships, and trying to settle the matter. Your lordships, this has took place in 2023 itself, that is, they have formalized their bond with consent, your lordships. The fact she said with consent they have decided to marry, with voluntary consent when she was a major, your lordships. After that, your lordships, coming up and saying, your lordship, this should be a ground wherein the settlement is not being done in accordance just to prolong the procedure, your lordships. Coming down to another guiding principles which have been laid down, your lordships, that whether the possibility of conviction is remote and bleak, your lordships. Your lordships, if we understand all the relevant facts and the circumstances of the case, and if we take into consideration the Kunal Chatterjee versus State of West Bengal, the court said no medical evidence, no corroborated evidence, no forensic evidence, and after that that a delay of 3 years. That was also not considered, Your Lordship. On these all grounds, the court decided that the possibility of conviction is remote and bleak, Your Lordship, and after that the court paused the proceedings after the delay of 3 years. The court didn't even consider the delay of 3 years, Your Lordship. In this case, the delay is of 10 years, Your Lordship. How can this fact be considered, Your Lordship, that the delay is of 10 years, Your Lordship? There is no plausible explanation given for the delay of 10 years, Your Lordship. Coming down to certain landmark judgments, Your Lordships, which I would like to present in before this honorable bench. On page number 16, Your Lordships, which talks about whether subsequent marriage acts as a settlement, Your Lordships. I would like to refer to the judgment of K. Dandapani versus the state by the Inspector of Police, Your Lordship. This is a very landmark judgment, Your Lordship. This has been referred in every Supreme Court judgment, Your Lordship. In this case, Your Lordships, the maternal uncle, Your Lordships, raped a 14-year-old niece, Your Lordships. After that, at the age of 15, she had her very first child. At the age of 17, she had her very second child, Your Lordship. The trial court convicted, the High Court convicted, but when the matter came down to the Supreme Court considered that, Your Lordship, that marriage was a settlement between the two, Your Lordships, and he was freed, Your Lordships. The accused was not convicted by the Supreme Court, Your Lordship. This is the landmark judgment referred in all the judgments, Your Lordships, with respect to this. Your Lordship, there are various other judgments I would like to refer. In Anand versus State, Your Lordship, the Honorable Supreme Court allowed the compromise and paused the proceedings for rape on the ground that the accused married the victim, Your Lordships. Another judgment is in Jatin Agarwal versus State of Telangana. Involving rape case was paused as the victim got married to the accused. It was a case where an FIR had been lodged against the accused by the victim for the offence under section 376 IPC, Your Lordships. Another judgment which I would like to cite is in Kapil. I would just like to seek an extension of 1 minute, Your Lordship, just to sum up my argument.
Yes.
Much obliged, Your Lordships. In the judgment of Kapil Gupta versus State of Delhi as well, Your Lordship, the Supreme Court caused the FIR registered under section 376 of IPC as the matter was settled between the parties through marriage, Your Lordship. Hence, Your Lordship, the subsequent marriage, Your Lordship, we are not claiming, Your Lordship, that the subsequent marriage, it simply means, Your Lordship, after the subsequent marriage, she was staying in 2 years. Stable matrimonial home, Your Lordship, it simply means the fact suggests that she was, for the 10 years, she was happy, Your Lordships. With that is, it simply means their lifelong bond which is there. She was staying in a happy marriage, Your Lordship. Just because the marriage has broke down, she has come to this honorable court just to seek personal vendetta and personal grudges, Your Lordship, against my client. Hence, Your Lordships, it is humbly prayed from me that the Honorable Court may be pleased to hold that the High Court is fully competent to cause the FIR under Section 528 of the BNSS and accordingly cause the proceedings in the present matter just so as to secure the ends of justice and to prevent the abuse of the process of any court, Your Lordships. If the Honorable Bench does not have any questions, I will.
What is the distinction between an advocate and a counsel?
Advocate simply means, Your Lordships, after the exam of Bar Council, a lawyer gets converted into an advocate. I'm not aware about what the council. I guess
You represented as a counsel, therefore I'm asking you.
Your Lordships, if I'm not wrong, I just seek ignorance for that. But I feel the counsel and the advocate words mean the same. As per me, Your Lordships. May I ask the co-counsel to proceed with issue 2 and issue 3? Much obliged, Your Lordships.
Counsel is permission to approach the rights?
Yes.
Much obliged. The present counsel will be dealing with issue 2 and issue 3 respectively. Issue 2, which reads as whether the strict liability regime of the POCSO Act, which nullifies the consent of a minor, should be interpreted through the lens of adolescent autonomy in the cases involving voluntary, non-exploitative romantic relationships between peers. It is humbly submitted, my lords, that this issue is not only about a strict interpretation of a statutory provision, but also about ensuring that a certain legislation does not defeat its own purpose. POCSO, Protection of Children from Sexual Offences, is a special legislation enacted in 2012 for protection of children from sexual exploitation and sexual abuse as per the statement and object of matters. Whereas, that is exactly the contention that the element of exploitation and abuse is completely absent in the present case. Whereas, POCSO has unintentionally criminalized organization connotes age 10 to 19 years as group of adolescents, where these group of children go through some changes, hormonal changes, psychological changes, and becomes normal for them to develop attractions for opposite sex. Due to the wide material available on the internet today, they tend to explore. My lords, the POXO Act deprives them of this right to explore and exercise their autonomy. My lords, the contention here is that the very act which is trying to protect the children is unintentionally subjecting certain children to criminal prosecution. This certain...
Whether do you want to argue that autonomous act contrary to law can be justified?
No, my lords. My lords, the contention is...
Only because well, a lot of information is available on the internet. Whether any person can tend to act against the law?
No, my lords. No person can tend to act against the law, my lords. But the contention is that certain intention, my lords, that the act that is done by these children is not with any wrong intention, is not with any criminal intention. It is just out of their it is just of their wishes to explore, my lords. It is just of their wish to exercise their autonomy. Because at the same age, they also do not understand the legal consequences of such acts and violence. That is the contention. These type of cases have been coming in front of the Honorable Court in recent times where such consensual relationships have been termed as rape. But my lords, rape being such a heinous offence should be segregated from such a consensual matter, my lords, because it is somewhat trivializing the seriousness of the offence of rape also, my lords, and also the offences that are covered under the POXO Act. The same observation was taken by a court in the case of Ashik Ramjai Ansari versus State of Maharashtra, page number 22 of my written submission, my lords, where the court held, while all children are entitled to be protected from sexual violence, such protection should also enable young people to extend their boundaries, exercise choices, and engage in necessary risk-taking, though not exposing them to inappropriate response, harm, and danger. Though the POXO Act cannot stop their natural feelings towards the opposite sex, particularly in the age which accounts for biological and psychological changes, punishing a minor boy who entered into a relationship would be against the best interest of child. And though it is the duty of the state to safeguard the ability to take decisions and to protect the autonomy of the individual, the adolescents cannot be deprived of this right. My lords, according to the National Crime Bureau reports, 25 to 30% of the POXO cases involve consensual sexual relationships. My lords, this number is not small. The same observation was taken by a court in the case of Prabodh Purke to the state of West Bengal, page number 21, where the court recognized the lack of recognition of consensual sexual behavior of older adolescents has resulted in their automatic criminalization, as well as confession of consensual sexual acts with non-consensual sexual acts. While all children and adolescents are entitled to protection from sexual exploitation and violation, the approach adopted under the POXO Act renders adolescents vulnerable to criminal prosecution for normative sexual behavior. Now let's further, the present FIR is lodged and the charge that is claimed is under section 3 and 4 of the POXO Act, which is penetrative sexual assault. Now the court has also taken a chance to explain the word penetration. That is there envisaged under the POXO Act, page number 20 of my written submission, where the court explained what exactly is penetration. Penetration, as envisaged in the POXO Act, has to be taken to mean a positive unilateral act on the part of the accused. Consensual participatory intercourse in view of the passion involved need not always make penetration by itself an unilateral positive act of the accused, but might also be a union between two persons out of their own volition. If the union is participatory in nature, there is no reason to indict only the male just because of the peculiar nature of anatomy of sexual organs of different genders. My lords, further, Arna was then age 17 and Neera was then age 15. As my co-counsel mentioned, that there is a close-in age exemption. And Honorable Supreme Court as well as the Honorable High Court in their various judgments have now recommended that there should be a change, that there should be close-in age exemptions, or they have called it the Romeo-Juliet clause. My lords, Neera being of 15 is claimed that did not understand the consequences, did not understand, but my lords, Arna being 17 was of the same age group, going through the same developmental stages, is expected to understand the legal consequences of these acts. My lords, how can this be termed as justice, I ask myself. Further, my lords, well, one is termed as victim and other is termed as accused, my lords, I ask myself, how can this be termed as justice? My lords, under the POCSO Act, the identity of the victims are always protected. But what about the accused? What about the societal repercussions to the victim are always talked about, but what about the accused, my lords? Because in such cases, even if, my lords, this accused, if they are acquitted or such proceedings are quashed, still the society brands them as rapists. Their whole career, their future is destroyed, my lords. My lords, the child protection mandate of the state and under the international conventions that India follows is also for the males, extends equally to the children who are male, my lords. Therefore, it is my humble submission where the cases involve consensual romantic relationships which are of non-exploitative nature, the court should consider the lens of adolescent autonomy and judge the cases accordingly. If the bench does not have any questions, the council would like to proceed to issue 3.
Tell me whether while quashing the FIR, in this matter, as per your contention, the FIR was against only the earner.
Yes.
Only. In this case, the termination of pregnancy was done.
Yes,
The
ma'am.
victim, with the consent, informed consent of the victim and the parent.
Parents, yes,
So
ma'am.
the parents were having the knowledge that there was sexual intercourse between them.
Yes, ma'am.
So at the time of quashing of the FIR, whether the court can consider that the parents of the victim and the parent of the accused had not reported the matter to the police. So they may be the accused in this case. So while quashing the FIR against only the earner, whether the court can consider that if the investigation is carried out further, then the parents of the victim and the earner may be the accused. So the FIR should not be quashed and let the investigation be done.
My lords, definitely under the POCSO Act, it is an application to report such offences if it is in your knowledge. And the parents, if you had knowledge, my lords, but what happens in such cases, as I talk about the parents of Arnav, my lords, because you mentioned, but my lords, in such cases there is a lot of social stigma, there is a lot of societal repercussions that are taken into consideration, and my lords, maybe because of such and maybe also because of the consensual relationship which has blossomed further also, my lords, the parents might have taken into consideration that they might marry further and therefore not have reported such offence, my lords.
Medical officer, it is his duty at the time of termination of pregnancy to inform the police.
Yes, my lords, it is his duty under the law to inform the police, my lords, but again the proposition is very silent and the council cannot make any assumptions. The council would like to proceed to issue 3. Issue 3 reads as whether the lodging of a criminal complaint after a significant delay of 10 years specifically triggered by the breakdown of a subsequent marriage qualifies as a malified exercise of the legal process intended to harass the petitioner rather than to serve the end of justice. My lords, this petition is filed, this FIR is filed for nothing but to harass the petitioner and is a complete abuse and of the process of law, my lords. My lords, firstly, delay of 10 years. My lords, the council is aware that there is no limitation as to file a offence or as to file a FIR in criminal proceedings, my lords. But the Supreme Court in its various judgments has explained why the FIR should be filed promptly. Why it should be filed promptly is because at that time, the name of the culprits, the name of the eyewitnesses and the evidence can be adduced. But my lords, if there is delay, a significant possibility of colored version creeps in. It also is an indicative of a fact that it is an afterthought and becomes a possibility that it becomes an exaggerated version, which is what is exactly in the present case, my lords. This version is nothing but an exaggerated and concocted version of what actually happened. My lords, council respects the precious time of the court and would not like to repeat the facts again, but as the facts said that there was 7 years of silence. My lords, as again rightly pointed out by your lordships, that if she was 15 and she did not understand the legal consequences, her parents were fully aware of the legal consequences and could have very well gone to the police and filed a report, my lords. But that was not done, my lords. Further, my lords, after attaining majority, after 4 years, without any external influence and out of her own volition, she had married the accused, my lords. This itself is evidence of her consent, my lords. Further, she stayed for 2 years in a stable matrimonial home, and after which there were personal differences, financial differences, which led to irretrievable breakdown, my lords. And conveniently, weeks after, that is late 2025 and January 2026, the report is filed. Weeks after, This is nothing but an abuse of process of law, my lords. My lords, the court has said that such activity should be condemned. The court, page number 27 of my written submission, in the case of Samadhan, Sitaram Moot versus State of Maharashtra held, the court has on numerous occasions taken note of disquieting tendency wherein failed or broken relationships are given the color of criminality. The offence of rape, being of the gravest kind, must be invoked only in cases where there exists genuine sexual violence, coercion or absence of free consent. To convert every such relationship into an offence of rape, not only trivializes the seriousness of the offence but also inflicts upon the accused indelible stigma and grave injustice. Such instances transcend the realm of mere personal discord. The misuse of criminal justice machinery in this regard is a matter of profound concern and calls for condemnation. Alas, further, the delay of 10 years. Alas, the court questions even delay of 29 hours, 1 day, 2 day, 3 day, and asks for a plausible explanation, my lords. Here the delay is of 10 years, and there is no plausible explanation as to such delay, my lords. Whereas in the case of Mahesh versus State of Maharashtra, one case is already submitted by co-counsel, that is Kunal Chatterjee, where delay of 3 years was rejected. My lords, other cases, Mahesh versus State of Maharashtra, wherein it was the same, the case of POCSO, delay was of 6 years, my lords, and the High Court, considering Kunal Chatterjee as a precedent, has paused the proceedings in the present case also. Well, therefore, it is not that today is the first time that there is such a delay. The court has previously considered such delays and paused the proceedings.
Tell me whether the delay is the matter of fact or it can be considered as a law point.
Pardon?
Whether delay is the matter of fact only, so the explanation is required during the evidence or only that the considering the period of delay that can directly be considered as a question of
the court has what the courts have said that if plausible explanations are offered, the courts have already said that delay cannot be a ritualistic formula to pause the proceedings. But my lords, it puts the court to search whether there is a plausible explanation given to such delay, my lords. That is what is the contention, that there is no plausible explanation in the present case. And that is why, considering the whole time frame, the conduct of the parties, this is nothing but the abuse of the process of law. Further, again, my lords, that the fact that these cases have various adverse impacts on the accused in such cases. What about the accused reputation? What about the accused family's reputations, my lords? The court, just a minute, can I take a... The court in the state of NCD versus Toshif case said that even if such accused are acquitted, the loss of reputation, incarceration, social stigma and psychological trauma suffered by an accused who is ultimately found to have been falsely implicated may leave scars that remain unhealed for a lifetime, just as the violation of dignity and bodily integrity. Further, my lords, because of such false implications, the court also made an observation that cases of false implication have become a general rule and cases of real sexual abuse have become an exception. My lords,
Please read this observation.
that's it. My lords, page number 26. Vivek Kumar Maurya versus State of UP. This court is finding that genuine cases of such sexual offences are now exception. The general rule is a false implication in cases of sexual offences. Implication in case of sexual offences sure short way of punishment before trial. Therefore, my lords, this is also leading to trivializing the seriousness of the offence, such grave as POCSO, as grave as rape. And it is also leading to the disbelief of society who believes in this court of justice, where the court will serve inherent justice and will not close its eyes just because of a strict mandate method. Therefore, my lords, if there are any, the bench does not have any questions, the council would like to proceed to prayer. Mother. Therefore, in the light of the issues raised, arguments advanced and authorities cited, may this honourable court be pleased to quash and set aside the first information report dated January 2026, along with all consequential criminal proceedings initiated against the petitioner as being a gross abuse of the process of law and a malified attempt to give a criminal colour to decade-old consensual adolescent relationship. to humbly pass any other order that it deems fit in the interest of justice, equity, and good common chance, all of which the petitioner, as in duty bound, is most humbly and respectfully submitted.
Now, what is the harm in facing the trial?
Well, as the harm in facing the trial is that Arnav will be subjected to the subjected to the trials, will subjected to the such harsh cross-examinations, and will have to go through the long process of the trial.
In criminal trial, whether the accused is subjected to cross-examination?
My lord, apology. Meaning the whole contention here is that he will be subjected to a long trial.
So whether questioning would not amount to curtailing the opportunity of the other side in proving their case or establishing by adducing evidence?
My lord.
Now, if you say, suppose you have a strong case, what's the harm in facing the trial? They will also get a fair opportunity of proving whatever they say.
My lord, even this honorable court is today is a fair opportunity for them to prove their case, my lords. And my lord, what?
How, in a question proceeding, how they get an opportunity to prove their case?
My lords, the delay. My lords, today if an plausible explanation for delay is offered and prima facie the case is proved for an offence that has happened, the case may proceed to trial, my lords. But my lords, the contention here is that prima facie on the factual matrix, the case, an offence is not made, my lords. My lords,
How can this statement be made at this stage?
Offense cannot.
The facts are very crystallized.
Offense
There
is
was a
not-
consensual act, okay?
definitely.
Whether it constitutes offense or not, whether the delay matters or not, whether the delay can be explained or not. These are all the questions of trial.
My lords, the honorable court has before in its precedence considered the delay in the question of quashing the proceedings and also considered the malified motive and the abuse of the process of law, my lords, because if this proceeds to trial, it will again amount to the abuse of the process of law, my lords.
You know, each case has to be decided on its own merit and fact,
Definitely.
and all the cases are not having the same facts.
Definitely.
So each case is depending its own fate, and furthermore, if you are saying that the accused will have to face the trial, long trial, then all cases should be quashed. All the FIR should be quashed, because the same result will be with the other accused who are facing the prosecution, or if the FIR is registered against an individual, then he will have to face the trial. So he can also say that he will have to face the trial, therefore that will be the abuse of process of law, and therefore the FIR should be quashed.
My lords, definitely that every
And one more question, that only on the basis of the victim the offence cannot be proved, or there is requirement of the medical evidence in rape cases or in sexual offences?
My lords, if I may answer this question first, that my lords, there is a concept of sterling witness that on the basis of only the testimony of the victim, an accused can be convicted in the cases of rape offence. But my lords, the version of the victim has to be completely believable and has to be completely strong. When there is even a possibility of colored version, the court has to look for corroborating evidence and then consider the facts and circumstances of the case.
It is admitted position that there was sexual intercourse between them, and therefore she was conceived and the pregnancy was terminated. So evidence was there that there was sexual intercourse between them. Whether that was consensual or not, that is to be considered at the time of trial. So at this stage, whether only on the ground of delay, that can be quashed, the FIR can be quashed, though there is precedent, and whether the parity can be considered in all cases.
My lords, as you said that each case depends on its own facts and circumstances. Again, that is exactly what my contention is. The present case, the facts and the surrounding circumstances itself are evident of the matter that this is malified excess of law, my lords. But further, that the contention that a delay and other evidences can be appreciated at the stage of trial, my lords. But my lords, what about these cases? Because this is a case of false implication, my lords. Just because this will set a precedent that any person coming after 15 years and 20 years to the honorable court or knock the doors of justice saying that this happened with me, my lord, and which will open the floodgates of cases to already overburdened courts, my lord. Therefore, my lords, it is a submission that considering the facts and circumstances of the present case, and as you said that it is different from each case, this case is different and considered to quash the proceedings, even if this involves POCSO, because an offence prima facie cannot be made out. Yes, there was a pregnancy, which is evidence of consensual sexual intercourse, definitely, my lords. My lords, but it is not a matter of dispute here whether it was consensual or not, because the factual itself says it was consensual. So the consent here is already admitted by the prosecutrix herself. Further facts are admitted by the prosecutrix herself. Therefore, my lords, it should consider all the relevant facts and circumstances and conduct of both the parties in such cases.
Whether her consent can be said to be a valid consent?
No, my lords, the consent cannot be said to valid consent, but my lords, there are plethora of judgments, or the courts have said that merely it is not about age, but it is about consent. That in some cases, even a 15-year child is mature enough to understand the consequences of her act. And therefore, just because of the strict mandate, the court should not punish the people.
The judgment of Varadarajan is applicable in POCSO cases?
My lords, can I take a minute to...
Yes.
Unless the council is not aware of the judgment. If the bench does not have any questions, the council is honored to present the
My lords, the council seeks permission to approach the dice. Much obliged, your lordship. So, your lordship, we are the council representing on behalf of the respondent in the present matter of Arnav Rajput versus Estate of Varundesh and Anand. I, as speaker number 1, as council, will be dealing with the issue number 1, and my co-counsel will be dealing with the issue number 2 and 3 along with the prayer. The council seeks permission to give a brief summary of issue number 1 to just give an idea about the contentions of the respondent. Much obliged, your lordship. Issue number 1 revolves around the question whether the High Court, in exercise of its inherent powers under Section 528 of the VNSS, which is corresponding to Section 482 of CRPC, is competent to question FIR involving non-compoundable offences under the VPOCSO Act, where the parties have subsequently entered into a valid matrimonial relationship. My lords, the respondent respectfully submits that the inherent power of the Honorable High Court should only be used in very rare situations and with great care. It is not possible to use these powers in a way that goes against the purpose of special laws that were made to protect weak parts of society. The Varundesh Protection of Children from Sexual Offences Act is a law that was made to protect children from sexual abuse and exploitation. Offences under the Act are very serious crimes against society. The accusation in this case were about penetrative sexual assault on a minor, which is clearly covered by the VPOCSO Act. The subsequent marriage between the accused and the victim cannot be utilized as a basis to exonerate with the accused for criminal responsibility. If we accept this kind of reasoning, it would set a bad example and let criminals avoid punishment just by marrying the victim. Additionally, judicial precedents have consistently maintained that serious offences, especially sexual offences against women and children, cannot be dismissed solely based on a settlement. These kinds of crimes are not just private matters, but they are crimes against everyone. So, the respondent seeks permission to start with the argument. The respondent would be supporting his arguments on issue number 1 on the following grounds. Firstly, the inherent powers are extraordinary and must be exercised sparingly. Secondly, the disclosure of prima facie cases which necessitates trial. Thirdly, public interest outweighs private settlement. And fourthly, strict liability and irrelevancy of consent. Sir, your lordship, the respondent humbly submits that in general terms, the High Court must not exercise its inherent jurisdiction for striking off the FIR under the facts of the present case. This is because the offences under the VPOCSO Act are non-compoundable, absolute in the treatment for consent for minors and based on public interest. Hence, the fact that a marital relationship has come into being between the accused and the victim does not per se warrant striking or unjust. Sir, the respondent contains the arguments on first point that the VPOXO Act statutory framework makes it evident that it is a unique piece of public welfare legislation that was passed with the primary goal of safeguarding children from sexual offences and guaranteeing a strong criminal justice response. The Act is preventive, protective and deterrent objects safeguarding the dignity and bodily integrity of minors. The Honorable Supreme Court emphasized the seriousness of such offences and the legislative intent behind the Act in a case of State of Madhya Pradesh versus Madan Lal, in which the Honorable Court noted, page number 10. The court noted that the purpose of the Act is to protect children from sexual assault, sexual harassment and pornography, and to provide for establishment of special courts for trial of such offences. The court also underlined that crime against children are offences against society as a whole rather than a private dispute. Additionally, the Act reflects a strict liability framework by nullifying the notion of consent with regard to minors. The Supreme Court ruled in Independent Thought versus Union of India that a child is presumed to be incapable of giving consent, meaning thereby that any sexual act with a child is an offence regardless of consent. This interpretation removes the offence from the category of private dispute. Furthermore, the Act's non-compoundable offences emphasize the prosecution's public nature. Sir, the Supreme Court ruled in Jhan Singh versus State of Punjab, case is referred on page number 11. The court ruled that heinous and serious offences of mental depravity or offences like murder, rape and dacoity cannot be fittingly quashed even though the victim or victim's family and the offender have settled the dispute. Offences under VPOXO Act, which are regarded as crime against society, falls under this principle. Therefore, the statutory framework affirms the non-compoundable and socially significant nature of offences under the POXO regime by clearly stating that they are matters of public concern prosecuted by the state and incapable of being diluted through private compromise. Next contention of the respondent is that in order to avoid miscarriage of justice, it is submitted that this Honorable Court inherits jurisdiction under Section 528 of the BNSS is an extraordinary power that should only be used in extreme cases. According to the established legal position, these powers are not meant to obstruct lawful criminal proceedings from the start. In this case, the FIR clearly shows that there are serious allegations that need to be investigated. Therefore, if there is any interference at this stage, it is abuse of the inherent powers of the High Court and not its proper exercise. It is most respectfully submitted that at the stage of questioning, the court is not required to assess the veracity of the evidence but to see if the allegations point to the commission of an offence if taken at the face value. Sir, a landmark case of Amit Kapoor versus Ramesh Chandar on page number 12, the court recognized that at the stage of framing of charges or while exercising jurisdiction under section 482 of CRPC, the court is not concerned with proof but with a strong suspicion that the accused has committed an offence. The court should not conduct a meticulous examination of the evidence or evaluates its sufficiency at this stage.
So in the case of Amit, there was charge sheet filed by the prosecution by the state, and the question before the court was framing of the charge. So the material was very much before the court. But now in this case, yet only the FIR has been registered and yet the investigation is proceeding. So whether that will be applicable. And another question is the authority cited by the petitioner for quashing of the FIR, whether the case of Jhan Singh was considered in that case while quashing the FIR.
Sir, in Jhan Singh's case,
In Jhan Singh case, as per your contention, the rape, murder and other cases, the heinous offences cannot be compromised and the FIR cannot be quashed in respect of those offences. but in the cited authority by the petitioner, the Honorable Apex Court has quashed the FIR only on the ground of delay and considering the other circumstances. So, whether in that case the authority of the cancelling was considered by the Supreme Court, or that is for inferior.
So, the case, firstly, the council seeks ignorance about the case which the learned council has explained. Secondly, sir, we actually, because of the some inabilities of the council, we are not able to submit a case law which we recently got to know that was delivered 7 days before by the Supreme Court, that the FIRs cannot be quashed on the basis of delay only. The Supreme Court has held that the Honorable High Court should not dispose of the application only on the basis of the inherent jurisdiction. They must consider the nature and the gravity of the offences that was done on the victim.
Now suppose the marriage was normal for 20 years and the discord arose after 20 years. FIR is lodged after 20 years. Whether this argument will sustain in that case?
As per law, if we go as per law, the consent would be irrelevant because...
So a happy marriage, a normal marriage of 20 years, it breaks into a discord and thereafter a 2-decade-old incident is taken as the ground to set the criminal law in motion.
Sir, I would like to contend that as per my knowledge, what I have been informed, that law does not provide any such limitation for filing such offence. Law does not provide any limitation.
Is there no limitation in criminal law? The same point was argued by the other side. Is there absolutely no limitation in criminal law?
For offences which have punishment of more than 3 years, the law does not provide any limitations for filing of the FIR.
Now suppose they were happily married for 50 years and thereafter they landed into a discord. Then what?
It would be an abuse of process because if the marriage is going well, but on this case it cannot be implemented because our respondent, our client may be thinking of the compromise that the marriage is going well, so she should not know, was not able to file an FIR, but later maybe she got to recognize that what happened to her 10 years before was wrong.
So whether your client can use that incident as a trump card for the entire life?
If there had not been any discord between them, then
May I discuss?
Yes.
So, the respondent submits that the question which was asked by your lordship was the question which should be determined at the point of trial court. And secondly, yes, these trial, but the case can be tested. The continuation of the case is not only warranted but also necessary to uphold the rule of law. Sir, your lordship, the legislation only concerned with providing relief to individuals, but is also concerned with addressing the larger social evil of child sexual exploitation. Hence, any private settlement, compromise, or marriage cannot take precedence over the obligation to prosecute. Sir, this is because such offences have a serious impact on society and cannot fall within the scope of private settlement, which is precisely the case of child sexual offences. Thus, the statutory regime clearly establishes the character of the offences under the POCSO regime as being a public concern investigated and prosecuted by the state. The legislation clearly states that a minor cannot provide legal consent, and regardless of any later development, the act committed by the accused while in a position of authority over the minor does not lose its legal status as an offence. Allowing this type of summary questioning action circumvents the constitutional rights to due process by denying the right of the trial court to conduct a complete and thorough examination of relevant facts before rendering a judgment. Sir, it is argued that the petitioner's claim about the nature of the relationship, the delay in filing the FIR, and the alleged verified intent are contentious issues of fact that cannot be decided in Section 528 proceedings. The issue brought by the petitioner necessitates evaluating the evidences, questioning witnesses, and determining credibility, tasks that are solely within the trial court's purview. It would be illegal to turn questioning proceedings into a full-fledged trial by considering such arguments at this point. As a result, the case must go on trial in order to be properly decided. Lastly, it is submitted that the petitioner is misguided in relying on the delay in filing the FIR. The law is well settled that delay by itself is not a ground to quash criminal proceedings, particularly in cases involving serious allegations. The Honorable Supreme Court ruled in Dinesh versus State of Rajasthan, page number 15, that although a delay may raise suspicion if it is not explained, it does not automatically invalidate the prosecution's case. Delay in delicate matters are frequently caused by familial pressures, emotional trauma, and social stigma. In this stance, the delay needs to be considered in light of the surrounding circumstances, which can only be done at trial. Without giving the prosecution a chance to clarify the delay and prove its case, quashing the FIR only on the grounds of delay that would be tantamount to prejudging the case. Sir, delay therefore does not justify the use of inherent powers and cannot be determining factor at the threshold stage. Therefore, the respondent would praise that the case must go on a trial and the application filed by the petitioner of quashing must not be considered by the Honorable. If your Lordship does not have any further question, my co-counsel would like to continue with my question.
Much obliged, Your Lordship. The speaker number 2, on the behalf of the respondent, is going to address issue number 2 and 3, following with the prayer. If Your Lordship allows, the Council would like to begin with the advance argument on the issue number 2. Much obliged. The issue number 2, which revolves around whether the strict liability under the POCSO Act, which nullifies the consent of a minor, should be interpreted through the lenses of the adolescent autonomy in the relation where it is a voluntary and non-expectative relationship. Here, the Council for the Respondent most respectfully submits that the strict liability regime under the POCSO Act must be applied absolutely firm, and any attempt to dilute it in introducing the concept of adolescent autonomy would legally impermissible, constitutionally unsound, and contrary to the legislative intent. I would like to back these arguments on the grounds of: firstly, the POCSO Act grants absolute protection to the minors. Secondly, the strict liability is a deliberative legislation policy. Thirdly, accepting adolescent autonomy creates a loophole within the statutory. Fourthly, so far there is no statutory law made and the doctrine of the cautious omnibus applied in this case. And fifthly, the application of the section 3, 4, 29 and the 30 to the same. The Council seeks permission to begin with the advance argument. Firstly, The VPOXO Act is a special law granting absolute protection to the minor. Here, it is submitted that the VPOXO Act is a special and a self-contained legislation enacted with the sole objective of protecting children from the sexual offense and preventing the dignity and the bodily integrity. The Act clearly defines a child as a person below the 18th year age, and it creates a bright line rule that states that an absolute protective framework where the consent of a minor is legally irrelevant. Further, it is submitted under the VPOXO Act. It adopts a strict liability standard, meaning no mens rea are required regarding the consent, nor no defense of the mutual relationship can be taken by the petitioner. Further, the point number 2, the strict liability is a deliberative legislation policy. The legislature has consciously avoided case-by-case inquiry into consent and create a uniform rule. This is because minor lacks emotional maturity, cognitive capacity, and legal understanding. Thus, any sexual act involving a minor is a crime per se, irrespective of the circumstances. In the case of MP versus the Mandal, in the year 2015, the court has stated the law should be applied in the strict sense only and keep the child safety and priority on the top. The law recognizes the children are vulnerable to manipulation, emotional dependency, psychological pressure. That is why, even when the consent appears, it is not maybe the free, informed, or voluntary. Thus, law eliminates consent altogether to prevent the misuse and ensure uniform protection. Thirdly, accepting autonomy directly will give loophole. Recognizing the adolescent autonomy will defeat the very purpose of the statute and becomes the protective mandate. Explain it. If court allows such a defense, accused person will reframe exploitative conduct as a romantic conduct, and this will shift focus from the protection of minor to the subjective evaluation of the relationship. Further, exactly what the legislature intended is to avoid. Introducing the autonomy will dilute the statutory. Second, while such relationship may exist, the law prioritizes protection over the recognition. Acceptance of autonomy would create a gateway for misuse and prosecution extremely difficult. Court would force to be determined whether the relationship was a romantic and whether it was a non-exploitative. These are the subjective, difficult to prove. Further, the accused can easily fabricate consent and influence the testimony. Thus, it will undermine the prosecution and increase the acquittal, become the deterrence. Further, there is no statutory exception exists for a romantic relationship. The absence of the exception in the statute is a deliberate and must be reached. The legislature was aware of the teenage relationship, yet choose not to provide an exception. This reflects the intention of the creating a blanket provision. Thus, the court cannot carve out an exception here. Further, the court cannot redefine statutory scope. Here, a doctrine of cautious omnibus should be used, Your Lordship. It states that the court cannot fill the legislative gap. It is a duty of the legislature to create a new law on the adolescent autonomy, and until so far, there should be no amendments or no judicial legislation shall be made. In the recent case, X versus the state of Maharashtra in the Bombay High Court, the Bombay High Court has clearly stated, up and until the legislature pass a new rule or new law, there should be no quashing of FIR based on the basis on the delay or any other grounds. Further, the doctrine of parents, the state's protective duty. The state has constitutionally obligation to protect the minor even against their own decisions. Minors are legally incapable of fully informed decision making. Thus, the law prioritizes well-informed autonomy, child approach seen in the child marriage laws, labor laws. Thus, restriction is not protective but a punitive. In the Indian marriage system, in the Indian society, the institution of marriage is regarded as a unification of the mutual kinship. And after the separation, it gives a courage, freedom and autonomy to the female, as it is so far said that in the Indian marriage system, there is a dominance of the male. So, if the FIR is caused at this stage, it will discourage the victim itself. So, the FIR, so for even filing the FIR, we are actually finding the ratio of the FIR in the matters is a very low. Application of the section 3, 4, 29 and the 30 of the VPOC Act is a criminalization irrespective of the consent. The very core of the POCSO Act is that it nullifies the consent of the minor or even the major. The penetrative sexual act involving a minor is an offence per se, irrespective of the consent or a relationship. Statutory clearly states any penetration is equals to offence. No exception for the love, consent or relationship. The legal position is absolute about it. Further, the section 29 provides for the presumption of commission of an offence. If any offence happened under the section 3 or 5 or 7 and 9 of the VPOC Act, it automatically shifts the burden of the proof on the accused itself to prove his innocence. Section 30 takes presumption for the culpable mental state. If in any case guilty mind is to be the question when the section 30 provides, the court shall presume the existence of the guilty mind.
So for using the presumption, certain facts are required to be proved, or directly the presumption can be used against the accused?
No, the law itself said that the court shall presume. Here the petitioner shall...
No basic facts are required to be proved by the prosecution.
Yes.
So if the presumption will be used at the time of the trial, when it will be decided whether he is committed that offence or not. At this stage also that can be used, whether presumption can be used at the time of quashing of the FIR. Or certain facts are required to be proved, and then the presumption can be used.
Grateful for your lordship, but in the response I would like to state, we are only creating in the interpretation of law in the judge's mind that this matter should be going for the quashing of an FIR, as you raise the concern about should this matter go to the FIR.
As you discuss the provision in the section 29 and 30 regarding the presumption, therefore I put that question.
Yes, absolutely, your sir. The basic facts should be clear. Facts should be applied.
And one more query, when there is no law or no provision is there, whether the Supreme Court or the High Court cannot interpret or fill that gap against the Supreme Court. If there is no provision, like when there was no protection to the women at their workplace, there was the judgment of the Honorable Apex Court in case of Vishaka. So that was used as the act or the guidelines. So if there is no provision in act, then whether the Honorable Apex Court can provide fill that gap by passing any judgment.
Your lordship, yes, the absolutely the Supreme Court can create a new law, but in the case of X versus State of Maharashtra 2025, it has stated that till and until the legislature passes a new law on the Romeo-Juliet clause, there shall be no quashing of an FIR. So, thus it create an exception to our case. If your lordship doesn't have any further question, we would like to begin the issue.
Yes.
Your lordship, the issue number 3 revolves around the question whether the lodging of a criminal complaint after a significant delay of 10 years, specifically triggered by the breakdown of the subsequent marriage, qualifies as a mala fide exercise of a legal process intended to harass the petitioner rather than serve the idea of justice. Here, your lordship, I would like to back my arguments on the following grounds. Firstly, delaying the sexual offence does not render the complaint false. Offence against the minor is not a crime against the individual but a crime against the society. Thirdly, the subsequent marriage doesn't extinguish the criminal liability. Fourthly, the issue of the delay, motive and the credibility are to be discussed at the trial. And last but not least, the inherent power should be used unsparingly. Further, your lordship, the counsel of the respondent most respectfully submit that the present petitioner, though lodged after the delay of 10 years, are subsequent to the breakdown of the marriage, does not amount to the mala fide exercise of the legal process, but a bona fide attempt to seek the justice after the serious offence committed against the minor. Firstly, delaying the sexual offence does not render the complaint false. It is humbly submitted that the delay in the lodging of FIR in cases involving the sexual offence, especially those involving the minor, is neither uncommon nor fatal. The Honorable Supreme Court in the state of Punjab versus the Gurpreet Singh and in the state of the Gopa versus Tulsidas Konkar has considerably held that the delay cannot be used as a mechanical ground to doubt the prosecution's case. Delay in the sexual offense must be used as a social and a psychological context. Here, Your Lordship. The victims are often delayed reporting due to the fear or the stigma of humiliation, societal pressure, family pressure, emotional trauma, or the psychological impact. Further, delay reflects the circumstantial compulsion, not the mala fide intention here. Secondly, offense against the minor is a crime against the society. It is submitted that the offense under the VPOX Act frameworks are not merely the private dispute between the two individuals, but the offense against the society at the large. In the Jian Singh versus State of Punjab, the Supreme Court held that the serious offense cannot be caused on the private considerations. The gravity of an offense outweighs the issue of the delay, as crime against the minors affect the collective conscience of the society. Thus, the law mandates strict protection of the minor, irrespective of the personal relationship or the delay. Thirdly, the subsequent marriage doesn't extinguish the criminal liability. Marriage cannot be used as a legal dependency, Your Lordship. The marriage between the two parties occurred after the offense of the offense. And at the time of the incident, the complainant was a minor. Subsequent marriage cannot be used as a shield to erase the criminal liability arising from the acts committed against the minor. Allowing such defense undermines the child protection law, encourages the offenders to escape liability through marriage. Any subsequent conduct, including the marriage, cannot retrospectively legitimize the offense because an offense is completed at the very utmost when it is committed, at the moment itself was committed. Thus, the liability must be asserted independently from the marriage. Further, the timing of the FIR not automatically indicates the mala fide intention of the respondent. It is submitted that the FIR was filed after the breakdown of the marriage. The timing of the complainant may raise the suspicions, but cannot itself establish the mala fide intentions in the matter. Breakdown of the marriage gives and provides the victim the freedom from the pressure, courage to report the offense. Thus, filing complaint after the post-marriage is a possible human reaction and not necessarily retaliatory measure used by the respondent here. Further, fourthly, delay and the motive and the credibility requires a trial. It is submitted that the question regarding the delay, mala fide intention, and the credibility are the questions of the fact. In the Niharika Infrastructure versus Private Limited versus in the Niharika Infrastructure Private Limited versus the State of the Maharashtra, the court must exercise the quashing of an FIR with the great caution, rare, and in the exceptional circumstances only. At the stage of the quashing, the court must only examine whether the prima facie offence existed, not the conduct related to the factual inquiry. Determination of the truthness of the allegations, motive behind the complaint, requires evidences and the cross-examination. Thus, this issue must be decided at the trial stage, not the hearing. Further, inherent power must be exercised sparingly. Quashing of an FIR is an exception, not a rule, especially in the serious offence involving the minor. The court should intervene only when no offence is disclosed nor the proceedings are manifestly observed. However, in the present case, the allegation clearly disclosed that it was a cognizable offence itself. Further, interference is unwarranted. The premature quashing would lead to the miscarriage of the justice. Quashing the FIR at this stage would be the denying the victim an opportunity to prove his case. Without the trial, evidence remains untested, the truth remains undiscovered. Thus, the premature termination undermines the justice, violates the fairness of the trial. Thus, I would like to conclude my point on the case law. On the page number of 19 on the respondent. At the Ashok Alok Srivastava versus the Union of India, the Honorable Supreme Court emphasizes that while deciding any case, it should be the conformity with the approach that can promote justice and the social interest. In the present case, while the petitioner relies on the delay, consent, and the subsequent marriage, it should not be an expense of the fair trial in the present proceeding. If your Lordship doesn't have any further questions, we would like to begin with the prayer. in the lights of the facts stated, issues raised, and the argument advanced, and the authority cited, hereby we most humbly and respectfully pray that the Honorable Court, Varun Desh, may graciously please to first dismiss the present petition filed by the petitioner, seeking the quashing of the first information report and any other criminal proceedings. Secondly, uphold the validity of the FIR and permit the investigation and the prosecution to proceed in accordance with the law. Thirdly, hold any offence under the BPC are serious offences against the society and therefore cannot be quashed merely on the basis of the subsequent matrimonial relationship between the parties. Fourthly, declare the statutory mandate of the VPOXO Act cannot be diluted or accumulated through the private settlements, compromises, subsequent marriage. Fourthly, affirm that the inherent power of the Honorable High Court under the under the BNSS Act, Section 528 must be used sparingly and with great caution. Last but not least, pass any order, direction or relief that the Honorable Court may fit and proper in the interest of the justice, equity and the good conscience.
I have two questions.
Yes, Your Lordship.
How does the presumption under Section 29 benefit you?
Thank you for your query. I will just submit something. The Section 29 states that here that the accused has a duty to prove his innocence. That is why it is up to the accused, and to prove his innocence, this matter should go on the trial. And we are here basically.
What is the presumption under 29?
That the
What is presumed?
Just a minute. Presumption is that it will be meant guilty until the innocence is proved. That is it. Much already, Your Lordship.
Rebuttal and some
2 minutes each.
Firstly, the learned counsel for the respondent relied on a judgment of State of Goa versus Tulshidar Khanolkar, page number 24 of their written submission, my lords, wherein conveniently they have quoted only a single line of that particular paragraph, my lords, which says that the delay in lodging the FIR cannot be used as a ritualistic formula for doubting the present case, my lords, but the paragraph extends further where the court says in case the prosecution fails to satisfactorily explain the delay and there is even a possibility of embellishment or exaggeration in the prosecution version on account of such delay, it becomes a relevant factor in questioning the FIR, in doubting the prosecution case and its authenticity. Further, the learned counsel has relied on the doctrine of factoring statute, which is the state as the guardian of children. State becoming the guardian of minors. That is exactly what is my contention, that the state should also be a guardian of minors who are accused also in such cases. Further, my lord,
The question of balancing the interests and equities will gather. Yes, if the state is situated in the same position for both the children, then balancing the interests and equities between the children will arise.
definitely, my lord, the question of balancing equities, which is also somewhere the question in such cases also, because there is a strict mandate and
Why do you think that you should be kept at a higher pedestal?
no, my lords, the contention is that we should be kept at an equal pedestal, not that the victim should be kept at a higher pedestal. My lords, further, the councils contend that if strict mandate or the lens of adolescent autonomy is applied, it will lead to judicial legislation, which is where the judiciary cannot interpret which cannot interpret law which does not exist, cannot interpret anything which does not exist in law. My lords, but if the court uses the lens of adolescent autonomy in these cases, it will merely follow the precedent set by the Honorable Supreme Court. It is already a precedent set by Honorable Supreme Court and High Courts.
Rebuttal. नंतर पेन नंतर
matter of Arnav Rajput versus State of Varundesh and another. The court is now adjourned.
We are thankful to you.
Tell us if there is any feedback for them, they are willing to wait for it, and then accordingly.
See, please understand the difference between an advocate and a counsel. You people are not counsel. Okay. A counsel is a person who has been designated by the Honorable Full Bench of the High Court or by the Full Bench of Honorable Supreme Court. Till then, we all are advocates. Okay. See, go through the definition of advocate in the Advocates Act. Okay. And all the best for the future.
All the best. Thank you.
I request everyone, after your lordship, because of phone call, you all proceed for the lunch, and then at that building, the main auditorium, at this building, the main auditorium, 7th floor, we all will gather for the valedictory and the presentation. Thank you. My lord.
Total correct. नहीं correct. Ten.